Yes, I greet you all, and today the topic of emphasis, or the topic that we are looking at, is the topic of land. And basically here what you have to know, or what you have to put in mind, is that you have to understand the introductory part of land. And if you understand the introductory part of land, then you are good to go about land law, both 1 and 2. The introduction is the genesis. It is the one that brings proper understanding of what land law calls for, or what land law means. You get? Today we shall look at the topic of, we shall look at what is land. We look at the rights on land. And basically here what I can say, and the layman's definition of the definition of land can mean a surface of the earth together. The surface of the earth together with all the things beneath and above it, either physically, or they are not physical. You get? That can be the layman's understanding or the layman's definition of land. But however, the RTA, which is the Registrations of Titles Act, Cap 230, defines what land means. When you read section 1 of the RTA, defines land to mean as messages, tenements, and hereditaments, such as corporal and incorporeal, in which certificate of title, transfer, and lease issued or made under this what? Act. You get? So the major keywords that we want to analyze is that they are messages, tenements, and corporal and incorporeal hereditaments. You get? Here what you have to know about something that is corporal and incorporeal. Something corporal, it's the one that has physical existence. For example, buildings, land itself, it has the physical existence. That is corporal hereditaments. Then incorporeal, this is something that doesn't have physical existence. You cannot touch it physically. And a good example is a mortgage and a lease. Those ones don't have physical existence. You get? But also they are under a definition of what? Of land. You get? So when you go further, there is a good case, which is Roger versus Lansdowne. Roger versus Lansdowne of 1966. Under this case, we realized that it was a fight whereby there happened a mining operation. And out of the mining operation, which happened in 1874 for the extraction of lead, the waste materials were dumped on someone's land. You get? Who was called the taxpayer in this essence. But when the waste materials were dumped, they spent over like 8 years. And in 1955, the taxpayer sold those waste materials, of which they had become what? Minerals. You get? So basically the question was, could those minerals have become part of land? Regardless, they were artificially placed there. So for it, court held that given the fact that the minerals, those waste materials that had become minerals, had spent 80 years and were covered by vegetation and trees, you get? This implied that they had become part of what? Part of land. You get? So basically, about that case, we have to know about that case, that it says that those minerals had become part of what? Part of land. You get? That is to do with the case of what? Of Roger versus Lansdowne. Yeah, it is Lansdowne. So basically, and when you go further, we have rights on what? Rights on land. Some of the rights on land, we have the right below the surface. Below the surface. These rights below the surface, they are in an umbrella that a right to mineral what? To mineral deposit. Remember, below the surface, nobody can live under the surface. But the only rights that we are looking at, the minerals that are beneath, that are under that surface. And the authority that we shall use here, it is the Constitution, the Grand Norm, 1995 Constitution, Article 244, Clause 2, mandates that, provides that all minerals must be exploited, taking place into account the what? The individual landowners, you get. And basically they must be exploited by the government, but putting interest of the land what? The landowner. And similarly we see it in the Land Act, that is section 44 of the Land Act of 1998 of the Land Act. It portrays that a person owns and occupies land and shall manage and utilize the land in accordance with the Mining what? Act. That is the occupant of that land. But however, when you read section 3 of the Mining Act, provides that, states that the entire minerals under the ground, or even if in water in the Republic of Uganda, shall be vested in the what? In the government. You get. But however, the government must compensate you before exploiting. When you read the Constitution, Article 244, Clause 2, you get. Those are rights below the surface. Then when you go to the rights to space above the surface. So basically here we see that if you own land, you have those rights. The rights what? Above the surface. Sorry, just on the surface. Those rights, you have them. To space, above the what? Above the surface. Now, basically here what you have to put in mind is that anything that is on your land, you own it. You get. And I will refer to the case of Metropolitan Railways versus Fowler. In this case of Metropolitan Railways versus Fowler, the court held that the ownership of the tunnel was to be regarded as ownership, as an interest in what? In land. You get. So basically the ownership of a tunnel was regarded as an ownership in the what? In the interest of land. You get. This deals in two ways. You have the right to space below the surface and the right to space above the surface. You get. So long as it is in your what? In your land. So basically, this gives you that essence there. Then we go to the rights to airspace above the land. The airspace we talk of where the planes pass, even if it is not where the planes pass, but that space that is around your land, that space, leave alone the ground, but look at the space. You get. If you own land, you own even that space. You get. So here, the right, I will use the example of what? Kelson versus Imperial Tobacco. In this case of Kelson versus Imperial Tobacco, we realize that the owner of the surface of land was granted an injunction to restrain a trespass. You get. Restrain a trespass by the neighboring landowner who had erected a signpost. And this signpost had exceeded 4 inches, just 4 inches, to his what? To his land. And remember, this what they call is that this signpost was above, but it had entered what? 2 inches, 4 inches. So the court awarded him what? An injunction. Reason being that he was the landowner, he owned that space. You get. And this essence here, court says that there is no need to show that there was damage to the land, or it damaged the what? The land, because of that action. Here the court held that trespass is actionable per se. You get. So basically, in this sense, you own the land, you own everything. No, but once there is a trespass, even though it hasn't brought what? That damage to your land, trespass is action per se. That is to deal with rights to the airspace, And another thing what you have to know is that however much you own the airspace, but sometimes trespass to your airspace may not be what? A trespass. cannot amount to trespass, whereby we have seen that modernization has come in. For example, if a plane passes, but the key here, the key point is that the distance, or the distance where the plane is a kind of far, is like 100 feet from the sky. For example, the planes where they pass, however much they are trespassing in your space, but those, they have their right, they have the statute that mandates them to do what? To pass through the airspace. That cannot mount what? To a trespass to your airspace. Because however much, actually the good case is the case of Bernstein versus Skyviews and General Limited. Bernstein versus Skyviews and General what? Limited. Here I realize that the plaintiff what? Claimed that he had been trespassed when it was a light aircraft had overflown in the land and taken a picture. You get a photograph of the height. It was around 100 feet high, but however the court held that this didn't amount what? To a trespass. There occurred no what? Trespass. Bear that also in what? In mind. Then when we go further, realize that we have the division of land into horizontal strata. What do they mean by the division of land into horizontal strata? Here basically what they are meaning is that, let me give an example. How can I say? As we move further, we shall hear of what they call condominium property. Condominium property, this is whereby you just own a floor, a room. You don't own the whole land, but you own a room on a particular building. So division of land into an horizontal strata is like you have someone that is owning the first floor, another one is owning the second floor, another one is owning the third floor. So there is also those rights. You say that this floor is mine, the other one is mine, the other one is what? Mine. You own a floor, but not the entire land. So that is the division of land into the horizontal what? Strata. I'll use the case of flood. The case of flood, the owners of the fourth floor flat do not own the surface itself, but they own the floor, that fourth floor. And in modern times, this is known as the condominium concept of real property. That's what the judge had to say in the case of flood. So basically, that's what you have to bear in mind. And those are some of the rights, or the brief introduction on what land is all about, on what land law is, on what we know, the brief introduction of land law. Thank you for listening. I wish you the best.